There might have been a motion today where kids are in crisis. That's not this case. You might have had a motion this morning about parents causing problems for their kids. That's not this case. You might have even had a case with a mother who's trying to steal someone's baby from the mother and deny her all her rights as a mother. That is not this case.
Notice how the attorney immediately focuses on what this case is not. This strategy is meant to calm the court, create contrast, and frame the dispute as cooperative rather than chaotic. Smart move. It sets the tone before conflict begins.
We have both filed documents to show you these are wonderful, thriving children, very loving and involved and well situated in their schools and community and their activities. And they're just great kids. And I used to have a t-shirt, great parents make great kids. So I think there's something to do with that these parents have done a good job with these two kids, a 10th grader and a 7th grader, both girls. Both these people, I'm sure, suffered in their own ways some unhappiness for years. In March, at a counseling session,
This is a subtle but important point. Dad didn't just leave the marriage, he prepared a home for the kids. In family court, effort matters. Judges don't reward parents who simply walk away. They reward parents who plan responsibly.
Father said, I can't do this anymore, and we're going to have to process a divorce. Mom doesn't want the divorce. In May, he found a home less than 6 miles away. The school is in between the two houses. It's brand new construction. The kids have their own rooms. There's a fully stocked bathroom, a fully stocked fridge. There's desks and chairs and thermoses and lunch boxes and everything else. So we have a good situation set up. Mr. Vanderwerf has tried to get some kind of parenting plan set up. In May, Mom said, well, let's wait till the summer.
Listen carefully to the tone here. Mom isn't refusing directly. Instead, she delays, postpones, asks to wait. In custody cases, passive resistance can be just as costly as outright refusal. Judges do not like stall tactics.
In the summer, there was just a series of excuses, delays, cancellations. Mr. Vanderwerf was saying, can we talk about this? And Mrs. Vanderwerf, I'll read you a couple of the texts, but she wasn't cooperative. He asked, well, maybe we should meet with a mediator. She wasn't cooperative. She said, having them stay with you isn't something I've agreed to yet. That was in June. Then there's just these things. Well, that won't work. Tomorrow would be better. Sorry, we're out. We ended up out. I'm in the middle of something. Tonight won't work. I'm okay with the girl spending the day with you. I'm okay with you having dinner with this one daughter. You can come to the house on Tuesdays and Thursdays at 7:30 p.m. and spend time with your daughters. So that's kind of how this went. We drafted a full proposal. Part of that was because the largest single asset is the home, the marital home with $450,000 or so equity. We'll find out. And we understood that Mrs. Vanderwerf wanted the home.
This is big. The father offered an entire parenting plan, holidays included. When one parent proposes a detailed plan and the other offers delays, the court sees a parent trying versus a parent resisting. It affects custody decisions more than emotions do.
The only way she can realistically keep it is to do a buyout, and but we'll figure that stuff out. So the main thing for the parenting is at this point, Mrs. Vanderwerf says, well, let's wait till the end of November. You know, we have to start something. If Mother had said, let's start the phase-in with what she calls phase 2, which is every Wednesday overnight and the weekends from Friday to Monday. And if she had said, we'll do the 2255, but not till January 2026, we wouldn't even be here. But they couldn't do that, so we need to get this going. We provided as our Exhibit 1 a fully laid out 2255 parenting plan with holidays and everything else situated. We have Exhibit 2 is the Michigan Child Support Formula calculation. The claim was father hasn't provided any money to mother. At the beginning of this year, there was more than $46,000 in a money market. Now there's $10,000. Where did the money go? Father used $5,000 for a down payment. Mother took $30,000 out. She tells the court that her income's just over $30,000. It's actually $34,000. We know that because now she says she gets $2,000 for coaching. And she told the insurance company when she signed up for benefits through the school that she was making over $32,000. But we calculated her at 32. We didn't calculate the 2,000. And that ends up being $812 a month. Her shortfall on her budget, which doesn't include a mortgage or a car payment, she gets health insurance through work, includes some fluff, but just looking at her budget, she says she has a shortfall of $380. Well, she's making over $3,000 more than she puts on her budget. But we'll figure the spousal support part out later. And
now, the defense shifts the narrative from schedules and cooperation to emotional attachment and routine. Notice how the lawyer tries to make the home feel irreplaceable. This isn't legal strategy alone. It's emotional persuasion aimed at the judge's heart, not just their brain.
I think either the house is going to end up being sold or we'll do a buyout of spousal support. But for now, hitting the $812, starting up the 2255 gets her budget covered because 812 minus 380. I mean, she's got money left over. We also had Plaintiff's Exhibit 3, which is the mutual restraining order. I understand that from counsel's submission that's fine. So that's what we're asking for, is to go with the full plan that we laid out, the child support that corresponds with that, and the mutual restraining order.
Thank you. Ms. Rademacher.
Thank you, Your Honor. Your Honor, we aren't dealing with a 6 and 8-year-old, which pretty much just go where they're told. We're dealing with a 12 and 16-year-old that have lived in this marital home their entire lives, mostly with mom, because mom was a stay-at-home mom for about 14 years. Dad travels, so he's in and out of that residence and was about a week a month. And he works West Coast time, so even when the kids have spent time with him, his schedule is such that it's 3 hours, so they're home in the evening with him, but he's still needing to work. So the children have the main custodial environment, and the status quo is, and their ages dictate that they don't want to play house somewhere else. Just because dad wanted to move doesn't mean that they want to move as well. Now, that doesn't mean that they don't want a relationship with their dad. The parties have cooperated and orchestrated continuing contact with the children. A lot of Mr. Vanderwerf's contact with the children was directly arranged between him and the children. So that's the schedule that he developed with them. In addition, like this August, September, he spent a lot more time with the girlfriend that now we've discovered he has. And he even no-showed for their daughter's dual cross-country with no text, nothing. So his mindset's a little skewed right now. We do have to get this case on schedule, but not because he wants to play house somewhere else. We need to honor the custodial environment that these children have. And that is why I have that phase 1, phase 2 schedule where it's a pattern that we're establishing. Kids, Wednesdays are dads. Weekends, every other weekends are dads. We'll start keeping you home on the evenings, but start getting used to the environment at dad's and being prepared for school in the morning and so forth. And that's why in phase 2, we can go in quickly within a 30-day cycle into a Sunday overnight and then the Wednesday overnights. This is very much taking into consideration the reasonable preference of the children. It was stated that the children want a 225. That is absolutely not what has been happening, nor is what we're hearing. I think these kids are being put in the middle, feeling perhaps guilty. I don't know. But the bottom line is, if we look at the pattern since May, these children continue to stay and have their routine, a 12 and 16-year-old in the marital home, and that's what is comfortable for them. And we can start with this transition, phase 1, phase 2, as I've indicated in my motion. The text that I heard, I asked my client, I believe they're taken out of context. And it is truly just working towards something. You know, these parties have never been divorced before. They don't know. As far as the financial situation, my client handled all the household bills in the house, and she transferred because Mr. Vanderwerf no longer deposits his check into the party's account from which he supported the family. And so he left the money market account for her to use, and she would transfer it to pay the bills. That's what she's done, and that's why it's dissipated. So we need to stop that bleeding, and that's why once we establish the child support, that will help. And the spousal support, I'm looking at a difference of him making $140,000 a year and her about $32,000. There's certainly a disparity. I don't think she has to live dollar to dollar. That's not fair either on this 28-year marriage. So if we look at the schedule that I've proposed, and I attached my child support guidelines as well, that leaves a child support amount, and a significant amount that I believe also does meet the budget for now. And we can reserve spousal support while we work out the rest of the details, as Mr. Zarnecki said. We don't include, keep in mind that their oldest son, Sam, who's 19, he goes to college in Albion. Mom has helped him in the past with tuition and things of that nature. He comes home from school, and the parties are going to just have to continue to agree on those additional expenses, which are not in this budget. So, Your Honor, this isn't a tug of war, and that was kind of my point of my little epithet in the beginning of my motion, is that we are dealing with real children, girls who are young adults that have their stuff, that have routine, that love their family, and want to do this in a methodical way, that they do not want to have complete disruption of their lives, living in two different, one on one side, 1 foot on the other. That is not fair to them, and that's why we asked the schedule that we did. I'd ask the court to adopt my child support number, because that would balance the budget, as well as take into consideration the flexibility that I think will occur. And the mutual restraining order, I don't object, of course. To the assets, I think Mr. Zarnecki put in there something about the harassing and that type of thing. I don't think we need a behavioral restraining order, but I'll leave that to the court's discretion, but no objection to a mutual restraining order regarding assets. Thank you.
Mr. Zarnecki.
Just like to add one comment, and I heard this is the only house the kids have ever known. They don't want to play house anywhere else. Mr. Vanderwerf wants them to play house somewhere else. There's a difference between a house and a home. These children will have two homes wherever the parents live. So let's just get off of that idea that this brick and mortar makes the difference and made these children great. It was these parents working together. Thank you.
All right, thank you.
Here comes the turning point. After listening to both sides, the judge must balance two things: the children's wishes and the legal need for progress. This is where stalled divorce cases finally move forward, even when one parent isn't ready.
I heard an agreement regarding a mutual restraining order regarding assets. So that certainly can be implemented as an order. And Mr. Zarnecki, you didn't really respond to the behavioral part of a mutual restraining order.
Well, I don't know what the harm is in telling people not to harass each other, but you can decide that, Your Honor.
Okay, all right. Let's leave it out for now. I hope it won't be necessary.
Okay.
because I'm not hearing a strong argument in favor. So, all right. As far as the parenting time, I understand this is difficult. It's difficult for the parents. It's difficult for the kids, especially difficult for teenage girls. Teenage boys probably would have similar issues. It's really crappy to have your parents get a divorce at any age, but certainly at this age. So I get that. But to counterbalance that, this family, it's been 6 months. And this family needs to start moving on and accepting kind of the reality of what's happening, and that there's a new reality, which involves two parents in two separate homes. But again, trying to take into consideration these children's natural feelings and reluctance for things to change. But the court finds that implementing phase 2 right now is appropriate in this case. Phase 2 was proposed by Ms. Rademacher as opposed to having a phase 1 then a phase 2. Just because at some point this Band-Aid needs to be ripped off, and I realize phase 1 was proposed to be a fairly short period of time, but I think given the amount of time that's gone by, let's just start with phase 2. The court will grant the mother exclusive use of the marital home. And I'm sorry, Mr. Sarnacki, what was your position regarding the spousal support?
Well, what I heard Ms. Rademacher say is that they want to reserve it, and I'm fine with that.
What about the child support?
Well, I think the child support that they're asking for is excessive because their budget underreported income that they've already admitted to the benefits department, and probably included all kinds of other things. But, if we picked a number in between, we can deal with that on the back end of the case. I don't remember what counsel's.
Can I ask what underreporting of income are you referring to?
She said she needs $30,000, but when she applied for the benefits with the National Services Insurance or whatever, she wrote down over $32,000. Then she also, that was for her salary. Then she also has now apparently $2,000 for cross country, so she's up to $34,000.
Okay, so I can tell you that the hourly rate she makes, and she doesn't get paid year-round either.
Interesting twist. The judge chooses a mid-range support number and makes it temporary. Why? Because smart judges avoid long-term financial decisions early. This keeps both parents honest while more evidence comes in.
Is exactly the amount on my child support guidelines of her salary, and then you would add $2,000 to that, so $32,843 is what her. I use $2,000 for her coaching, and then how much per hour? I've got it right here. She makes $20.84 an hour, and then she really works. She doesn't get paid all year round. So if you average that all out, that's where you get that $30,800.
Under penalty of perjury, she told the National Insurance Services that as an administrative assistant, she makes $32,177 working 40 hours a week.
Well, let me just interject a minute here.
It's not that far apart.
No, that was going to be the point that I make, and it's got to be a pretty significant bump in income for it to make a huge difference in the child support formula, as we know.
Right.
But this is only a temporary order, so I think $1,600 a month in child support and reserve on the spousal support is appropriate. And then that can be, retroactively modified depending on the proofs or the party's settlement.
Okay.
So we have legal custody, physical custody, and the 2255 question.
Well, at this point, joint legal and joint physical is appropriate. And then the 2255 question, I think, is something that the court can look at going forward. We will implement the phase 2 and see how that goes. And then with the idea that maybe phase 3 would be something like a 2255 if everything goes well.
Okay, thank you, Your Honor.
Anything else?
I'll prepare the order. Thank you.